Well, hello, everybody, and welcome back to Raw Law Unfiltered with your host, the DUI Guy Plus. Today, we are going to continue the Suitcase murder trial, Sarah Boone, State of Florida versus Sarah Boone. For those of you just joining us, we're actually about to conclude the case, but today is going to be a very, very big day. Last time we spoke, which was yesterday, I told you that this is going to be a boring day. Turns out I was wrong. Today is not going to be a boring day. Today is actually going to be a very, very interesting and entertaining day. Not only are we going to get the rebuttal witness, a doctor, probably a psychologist, I imagine, from the prosecution, but we are also going to watch the body camera footage. And I thought, oh, body camera footage, that's going to be a snooze fest. Turns out, and I spoke with Chandler about this, and she has actually watched the body camera footage on this case many moons ago. And she said it is going to be fire. It is going to be entertaining, and it is going to be interesting. The things that she says, Sarah Boone, her ex shows up, and the request that Sarah tries to make. I mean, I've heard like chatter about the things that she may or may not have said periodically, but now we actually get to see it. Now we actually get to see it from the horse's mouth, from Sarah's mouth, from the police officer's body camera footage. So that's going to be later today. We start off the day with the defense. The defense still hasn't closed their case. They are going to rest, presumably, the minute court resumes. That's what they were planning on doing yesterday. They were planning on resting, but they decided, look, we're not going to rest just yet. We are going to have a chance to speak with Ms. Boone, kind of give her an update, make sure that she understands. Because remember, she's the one running the show. She is the client. You always consult with your client. But in this case, it's kind of flipped. Sarah is the one running the show, and the lawyers are kind of backseat litigating. It's a very, very bizarre dynamic that they have. And I don't know how much I like it, but the lawyers have no choice. The lawyers have absolutely no choice. So, yeah. So that's where we are. So we're going to watch first we're going to hear the defense resting, unless they have another witness, which doubtful. The way that the attorney is kind of leaning back in his chair, the defense attorney, is it Owens? I think his name's Owens. I get them mixed up. Jay is the prosecutor and Owen is the defense. But anyway, yeah, so that's where we are. We're going to start out with the defense if they have any more witnesses, or they're just going to rest. Once they rest, the prosecution is going to put on their rebuttal doctor. Then they're going to play the body camera footage, they said, and then we're going to listen to and read some text messages that were exchanged presumably between George and Sarah, all done by the prosecution. Then if the defense has any rebuttal, I suppose, that's going to be in the afternoon. Then they have to do the charging instruction, which is the jury instruction conference. They call it a charging instruction or a charging conference in Florida, I believe. That's what they were calling it yesterday. And after that, they're probably just going to schedule the closing statements, closing arguments for Friday morning. So tomorrow, 24 hours from now, I imagine they're going to close. And after they close, the jury's going to go back to deliberate. And if they deliberate for more than 2 hours, honestly, I'm going to be quite surprised. Not shocked, because they have the battered spouse syndrome instruction, presumably, that's going to be introduced. Are the rumors about the defense lawyers true? Somebody's saying Mo in the deep end and Baker just talked. There's a motion that Boone's lawyers maybe made a money deal for the trial's TV show rights or something. Is that how they're getting paid for this? I know nothing about it. I'm kind of on the outside of all this. So I cannot confirm or deny. But what's the chatter? Talk to me, chat. What do you guys know? What have you all heard? A motion. Are you sure you mean to say it's a motion? Like a motion before the court? They told the judge they're representing her pro bono. We still don't have court audio, so I just have it kind of running in the background until court resumes. Oh, about hearing their side of the story. Oh, that's going to be interesting. Okay, neat scholar. So maybe we're going to hear it today. If there's a potential violation of Florida law, I mean, we haven't even finished 1 week of this trial and it's already about to be over. I mean, they're not really doing it for free. They're doing it for publicity, if nothing else. I mean, would I step in a case like this just to get some notoriety? Probably not. You have to like the client. You have to trust the client. It's very difficult when you don't like or trust the client. Because you have to remember, when you are representing someone pro bono, it doesn't matter that you are working for free. The client is going to look at you as their attorney. You've accepted, you've agreed, you took the case. It doesn't matter if it takes you an hour, 5 hours, or 500 hours. You are their attorney. You said you're going to take it pro bono. That's on you. So if you make some sort of like side deal, sorry, I'm a little congested today. Please excuse me. If they made some sort of side deal with like Court TV to get some royalties or something, apparently in Florida, there's a law that a lawyer cannot make a deal for TV rights before the trial is over. Gotcha. Gotcha. Okay, so if they made a deal and if they're in violation of the law, I guess we'll find out today. Maybe that's why the lawyer is so relaxed. He's actually very defensive.
Case number 2020 CF2603, the state of Florida versus Sarah Boone, and after names for the record, beginning with the state.
Chief Cacciatore on behalf of the state. William J. for the state.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah.
Ms. Boone, raise your right hand to be sworn. Please, do you swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God? I do.
Good morning, ma'am. Could you state your name and date of birth for the record for me?
Sarah Boone, 10-10-77.
Ms. Boone is seated at counsel's table, buttressed by her attorneys wearing a black suit and pink blouse. All members of our jury are present this morning. State, or is there anything we need to address before we bring in our panel?
No, sir.
Defense, anything we need to address?
Yes, Judge, I intend to introduce these two exhibits that have already been stipulated to. One is
No chatter about rights. TV rights are.
you've been walking the course of the interview.
Right now, your ID is A, as in the weight, and
Defense gets identification AB, Judge, which is the order dated June 16th, 2019.
I think so. Uber driver. I think so.
AC. And it is a
We could have done better, but I'll take it.
dated June the 19th, 2019. And then I'd like to introduce them into evidence. And and I'd like to hand publish them to the jury.
Okay.
And let them look at them one at a time. And then I believe we're gonna rest our case, but at some point, I guess you would excuse the jury because Sarah Boone needs to be questioned about.
And there may be additional motions to be addressed at that time. So yes.
Do we want to do that now before we're going to adjourn?
I don't have a problem with that. If you want to rest now, subject to those being entered and published, and we can address any motions. The court has reviewed both of the no contact orders. And that way we don't have to do a in and out. And I can colloquy Ms. Boone at that point in time, and we can proceed with the state's rebuttal case.
Subject to those, the introduction of those two exhibits just mentioned, the defense would be resting our case at that juncture.
Okay, all right. Yes, ma'am. Okay, I've been advised by the courtroom deputy that juror wearing badge 130, seat 10, cannot stay past 5:30 today. So just be advised. We'll use our time accordingly.
That was the 6th.
I don't believe so. Give me a moment and I can check. That is an alternate. It's alternate in seat 4.
Thank you.
Defense, do you have any motions?
Just out of abundance of caution, I would read new or motion for judgment of acquittal. Pursuant to defense resting. We'll do that now while the jury is still out. I don't have any additional arguments other than what was made the other day.
Okay, thank you. Any other additional argument, Mr. J?
Just that at this point in time, the standard is whether or not a reasonable trier of fact could find the defendant guilty. And there is sufficient evidence for that to be sent to the jury.
Thank you. The court recalls the arguments that were made after the conclusion of the state's case, both from the state and the defense. The court finds that a reasonable juror could make a finding of guilt on the elements of the sole charge in the information beyond and to the exclusion of each and every reasonable doubt. For those reasons, the renewed judgment of acquittal is denied. Ms. Boone, I have a couple of questions to go over with you, ma'am. You've been previously sworn this morning. Your attorney has indicated that all of the evidence and testimony of all witnesses in your case have been presented to the jury, with the exception of the 2 no contact orders pre-marked as AB from June 16, 2019, and the no contact order of June 19, 2019, pre-marked as AC, which once the jury comes back in, he will enter into evidence and produce them to the jury for their viewing. Are there any witnesses that you wanted to call that your attorney failed to call?
No.
Is there any evidence that you wanted your attorney to present that any of them failed to present?
No.
Are you satisfied with all of your attorneys up and until this point?
Very.
Oh, very.
Is there anything that you would like to bring to my attention at this time?
No, Your Honor.
Okay, all right. I did receive the proposed jury instructions this morning. I'll look at them during the lunch hour, and after the state concludes their rebuttal case, we can proceed with addressing those. Mr. Beck, yes, sir.
No, the defense did not receive the red line copies that the court discussed yesterday. I don't know if those were sent or not.
I emailed Ms. Barrios last night. Once we got out of court, I'll send them to everyone this morning. Just give me a moment and I'll get those out right now. Is there anyone else? The email correspondence that I have is Mr. Owens' email, Ms. Andrews' email, Mr. Cacciatore's email. Is there anyone else that they need to be sent to from the defense side?
We'll pass them around.
Okay. All right. Very good. Bring in our panel. State.
Yes, Your Honor.
Defense?
Yes.
All right, let's stand and bring in our panel, please.
Sorry, my camera froze for a second. Now it's got the thing in the corner. Give me a second. Here we go.
Jury's entering.
I don't know what happened. Thanks, chat, for pointing that out.
State, you recognize our jury.
Yes, Your Honor.
Defense, do you recognize our jury?
Yes, I do.
All right, thank you. Y'all can be seated. Good morning, members of the jury. Welcome back to 12 Alpha in the Orange County Courthouse. If you could, just raise your hands to confirm that you complied with the court's instructions last night during the break. I thank you. Record will reflect that all jurors have raised their hands. We're going to have a little bit of additional evidence presented by the defense this morning, and then we'll go from there. Okay? All right, thank you very much. Mr. Owens, you may proceed, sir.
Judge, at this time, I would move to introduce defense identification exhibit AB into evidence.
No objection to AB or AC.
What was pre-marked as defense AB will be received into evidence without objection as defense 19. And if you could just identify AC for the record, sir.
Judge, at this time, I would like to move defense identification AC into evidence.
Hearing no objection from the state, what was pre-marked as defense AC will be received into evidence without objection as defense 20.
And Judge, I would like to publish these to the jury and allow them to take their time and pass these down to.
You may proceed.
The first is defense exhibit 19. We'll just review it. Pass it down.
Is it better now? Is my video not properly acting? Because it's smooth on my end, but I don't know if you guys are seeing it smooth.
Next document is defense exhibit 20.
Let me try and refresh. Okay. Let's see if this fixes the problem. Is it better now? Okay, I'm sorry about that. I don't know what happened. That, that is the problem. Exactly, Mad Dog. That's what I like about this.
Thank you, members of the jury. Mr. Owens, any other additional witnesses, evidence, or testimony, sir?
No, sir, on behalf of Sarah Boone, the defense rests.
Thank you.
Defense rest.
Or State, are you intending on putting on a rebuttal case?
Yes, Your Honor.
You may proceed, sir.
Speak with Dr. Tanya Warner.
Dr. Tanya Warner. Hi, baby. What's up, baby girl? Your boy? Yeah? You want to play? I played with you already. Oh, you want more, huh?
shall be the truth, the whole truth, and nothing but the truth, so help you God? I do.
Doctor, good morning. Could you state and spell your name for the record for us?
My name is Tonya, T-O-N-I-A, Warner, W-E-R-N-E-R.
All right, thank you. You may be seated, ma'am.
Thank you.
Good morning, ma'am.
Good morning.
Where do you work?
I'm employed at Meridian Behavioral Health Care in Gainesville, Florida.
And what services do you render there?
I'm their chief medical officer.
And can you tell the jury what your educational background is?
Yes. So I graduated with an undergraduate degree at the University of South Florida in chemistry. I then attended medical school at American University of the Caribbean. I did a residency in psychiatry at Connecticut Valley Hospital in Connecticut under the auspices of Yale University. I then came back to Florida and did a fellowship 1 year in forensic psychiatry at the University of Florida.
And since your educational background, what have you been doing professionally?
Yes. So I'm a licensed physician in Florida. I am board certified in general psychiatry and forensic psychiatry. I was initially employed on faculty at the University of Florida from 1998 through 2015. I retired there as the vice chairman of the Department of Psychiatry and the director of the Forensic Institute. I then went to work as the chief medical officer at Meridian Behavioral Health Care, which is a community mental health center.
What is psychiatry?
So psychiatry is the treatment of mental health disorders.
And what is forensic psychiatry?
Forensic psychiatry is the interplay of psychiatry and the law. So anywhere where psychiatry intersects with legal issues.
What is the difference, if any, between a psychiatrist and a psychologist?
So a psychiatrist has gone to medical school where a psychologist has not.
And as a licensed physician, are you able to prescribe medication?
Yes, I am.
In the course of practicing medicine as a psychiatrist, do psychiatrists prescribe medication to treat mental disorders?
Yes, we do.
And when did you begin your work as a forensic psychiatrist as opposed to working at the faculty at the University of Florida, or was that concurrent?
In 1996 in the state of Connecticut, while I was doing my training at Yale University, I testified for the first time as an expert witness in the state of Connecticut.
And over the course of your career, have you done forensic psychiatric evaluations?
I have
Approximately how many?
thousands of times.
And does this include on matters such as competence?
Yes, it does.
And does it, just explain briefly to the jury, what does that mean, legal competence?
So competence is, do they understand the legal process? Do they understand who the different players are in the courtroom, who's on their side, who's not on their side, what they're charged with, what the possible penalties are, what the possible plea options are.
And have you ever done any forensic evaluations about insanity?
I have. I've done sanity at the time of the crime, and also I've been appointed by the governor of the state of Florida to do sanity for execution.
And have you ever been involved in working as a forensic psychiatrist involving the subject matter of battered spouse syndrome?
I have.
Can you describe your experience in that area for the jury?
I've been asked to do evaluations by the prosecution and defense several times with regards to, and it's come up in different cases, criminal cases with regards to intimate partner violence.
And does all violent episodes within a relationship result in something that we are describing as battered spouse syndrome?
No.
And I see there is a book in front of you. What book is in front of you?
Yes. So this is the Diagnostic Statistical Manual, and this is the 5th edition text revision, which is the most current edition.
Is battered spouse syndrome in there as a diagnosis?
No, it is not.
And where, if anywhere, does it fit into any of the categories within the DSM-5 TR?
It would come under one of the trauma categories. Most specifically under most likely post-traumatic stress disorder.
Can you describe for the jury what post-traumatic stress disorder is?
So this is a disorder that's recognized under the DSM for individuals who have suffered a traumatic event, and then they have re-experiencing of the traumatic event. They have different symptoms besides re-experiencing, such as hyperarousal, and also avoidance of triggers or symptoms, things that would trigger a response to it.
Are there any agreed upon criteria within the relevant forensic psychiatric and forensic psychological communities about battered spouse syndrome?
There are.
And what would those be?
So it's again, having experienced a trauma, repeatedly, violence within an intimate relationship, and then having symptoms secondary to that, avoidance, so tiptoeing around, trying to avoid recreating the violence.
And if a person experiences an environmental stimuli, something happens to them, another person does or says something to them, is their subjective reaction what is defined as whether there's trauma present or not?
I'm not sure I understand the question.
Let me rephrase it.
You can rephrase.
Calls.
You described there's a difference between experiencing a violent relationship and whether or not that person is going to experience trauma from those behaviors they witness and experience. Is that fair?
Yes.
Now I've lost my train of thought. Is it fair to say that an experience that a person has, whether or not that person believes it's traumatic, is a subjective experience?
Yes, each individual is different, and so each individual is going to take that experience differently.
Can hypothetically a couple be involved in a violent relationship for a number of years, even 3.5 years, and battered spouse syndrome not necessarily apply to either or both of them?
Yes, that's correct.
Can you explain that?
So again, each individual is different. So one individual may develop the symptoms of battered spouse syndrome, and one individual may not under the same exact circumstances, just depending on their makeup and what they've experienced in their background and their biological makeup.
And is there a cycle of violence that is sometimes used to describe battered spouse syndrome?
There is.
Can you describe that?
There is. So there's the initial, there's kind of a tension buildup section where you feel the kind of tension building up, and the individual can feel kind of the incident coming, and then there's the actual incident of violence. And then following the incident of violence, there's a honeymoon phase, what they call the honeymoon phase. And that's the third phase, where the individual who created the violence attempts to make up to the victim and recreate kind of the relationship and pull them back in. And then it starts all over again, where you feel the kind of tension start building up again to the incidents of violence.
Does abuse have to come in the form of physical or sexual violence?
No.
Can you explain your answer?
So it can also come in ways of coercion. It can come in ways of control, such as financial. So if an individual controls another individual financially, or controls their ability to drive or go out, their ability to be around their other family members or friends, kind of isolates them from other individuals, controls their ability to work, so controls their ability to make money or access to funds, so they can control them in any number of ways.
Is this kind of about like an inequitable power dynamic in the relationship?
Yes, absolutely.
Can a man be on the receiving end of emotional or physical or sexual trauma and potentially experience, strike that. Can a man be on the receiving end of verbal harsh words, physical violence, or sexual violence and end up having this syndrome of battered spouse syndrome.
Yes, it crosses all boundaries, and we see it in all types of relationships, whether it be heterosexual or homosexual relationships. We see it cross all boundaries.
And can this element of control come from controlling personal items such as identification papers?
Yes, absolutely.
Can control potentially, hypothetically, come from partner A gifting partner B an item, but still considering that item partner A's because he or she paid for it, even though it was a gift?
Yes.
And in this particular case, were you asked to do an evaluation of Sarah Boone?
Yes,
Do you see Ms. Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's sitting at a table there wearing a dark suit and a pinkish top.
May the record reflections identify the defendant?
Record will so reflect.
What date did you have an evaluation of Ms. Boone?
It was early in October, I believe October 2nd.
And this was at the request of the state of Florida
Yes, it was.
and subject to a court order?
Yes.
And where, who was present for this evaluation?
The defense and the prosecution.
All right. Tell us about the evaluation with Ms. Boone. What do you do first?
So I met with Ms. Boone at the jail in a conference room. Again, the prosecution was there and her attorney. I met with her for approximately 2.5 hours, just under 2.5 hours. I introduced myself and explained that the interview would not be confidential, that I would be coming to court if asked to share my opinions. And she agreed to participate. I then start out with just general information, so getting to know her, date of birth, kind of background information, who her parents are, childhood. I go through her educational background, work background, her marital background. I go through health, psychiatric background, any substance use issues. I do a mental status examination.
Can I stop you there?
Yeah.
Elaborate further on that.
So a mental status examination is just questions to determine kind of memory and cognition, kind of how their thought process is, how they're thinking. Are they able to kind of fluidly think through processes?
All right, go on after that.
And then I transitioned from there into walking through the incident that happened with her.
All right, what did she indicate occurred on February 23rd, 2020 to you?
All right. Is it all right if I refer to my notes just to
Just if you need them to refresh your memory, please do so, but don't read from them. Just let us know.
So she had a difficult time recalling what time they actually woke up that day. Initially, she said in the morning, and then she said she wasn't even sure that it was in the morning. She said that they both wanted to drink, but that she asked that they could clean the house first instead, and that they did some vacuuming and cleaning. They had a half a bottle of wine left over from the day before that they drank. She felt about 4 o'clock in the afternoon. They drank that out on the back porch. And she described that they had kind of 2 beach chairs out there and a dartboard, and that they kind of hung out there a lot on the back porch, spent time out there. They did a puzzle out there and completed that, and then did some kind of artwork. She felt like he was getting frustrated thinking about his life, that he had lost his job. And so she encouraged him to call his daughters, although she knew that that they did not like to talk to him when he was drinking. So I'm not sure why she had encouraged him to call them at that point, because they were already drinking. And she also at some point encouraged him to call his brother, because she wanted him to explain to his brother that he had pulled her down the stairs the night before, although that didn't happen. He didn't explain that to the brother. And according to her. And then at some point they went and got another bottle of wine and some cigarettes from the grocery store and continued to drink. And then they were inside the house, and then he, I guess, tagged her at some point and said, "Tag, you're it," which indicated that they were going to play hide and seek. And she said she went upstairs and hid in the shower and waited for him to come, and he never came upstairs. Excuse me. And so she eventually came out of the shower to look for him. And as she was coming down the stairs, she said she saw him slipping into a suitcase, which was on the living room floor, that they had put out because they were going to donate it. And sorry. And so she went downstairs and indicated that she had found him, and they were kind of laughing. And she zipped the suitcase up, and they continued to laugh, she said, at that point. And they were having a good time and laughing and enjoying themselves and having a good time. And she said, and then she became angry. And she said she remembered what it felt like when he was choking her, and she became angry.
What did she do after she became angry?
I'm going to refer to my notes at this point.
To refresh your memory, just
Yes.
put them down and then tell us what you remember.
She said that she shook the suitcase and that she lost control of it and it flipped.
And then what happened?
Then she said that he stuck 2 fingers out and her son's baseball bat was sitting there, and she picked the bat up and hit his hand.
Then what happened?
And then she went upstairs and waited for him to come upstairs.
Alcohol. Can you tell us what you know about the effects as a medical doctor of ethanol or alcohol on a human body?
Yes. So it causes intoxication, as we all know, and it causes disinhibition. It works on the frontal lobe of the brain and allows us to do things that we wouldn't normally do. It disinhibits us.
And in the course of your practice, have you ever come across a diagnosis of alcohol abuse disorder?
Yes.
And what is that?
Well, alcohol abuse is an old disorder. So we used to use alcohol dependence and alcohol abuse. It's now been combined in the DSM-5 and the DSM-5-TR. It's alcohol use disorder.
In considering what a patient or a client or somebody that you've been asked to evaluate by a government entity, do you take into account that person who's relaying the history to use a consumption of alcohol at the time of the history that they're given?
Yes.
Why is that?
Because again, it affects their behavior and their actions.
Does alcohol have any effect on a person's memory?
It can.
What, if any, relationship is there between acute alcohol use or acute alcohol intoxication and battered spouse syndrome?
Again, it can affect your memory. It can affect your reactions. It can affect your response to different things.
Does the disinhibitory nature of alcohol strengthen, weaken, or have no effect on battered spouse syndrome?
It would depend on each individual again.
Generally speaking, it is important as an evaluator to get as much information as possible before rendering an opinion, such as diagnosing somebody with something out of the DSM-5-TR or battered spouse syndrome.
Yes.
In this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening?
I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change.
And what was your opinion?
My opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
And specifically talking about,
Judge, if we could approach the bench.
Yes.
Okay. By the way, somebody was saying that my voice is echoing. Do you guys still hear an echo? I tried to fix it while the court was happening. Do you guys hear an echo when I speak? Okay, so maybe I fixed it. Okay, fantastic. Thank you. Awesome. So what I was saying, what I was about to say, what was I about to say? Oh, so the difficulty that I have with this psychiatrist, although she is, went to medical school and is better trained, better educated than a psychologist, 2.5 hour interview and she's going to say, "You don't have PTSD, woman." I don't know. I mean, to me, I think that's excessive to be able to diagnose someone after seeing them one time. But of course, I mean, the jury's going to take that into consideration. The defense is going to try and rip her apart that you just did one interview and it means nothing. Like they're bringing in these experts like they, like they're some kind of gods, and they're not. Mental health is an invisible thing. We can only see a person's actions. We can only see how they're acting and how they're behaving, but we can't really know what's going on inside their mind. And the blonde doctor, the psychologist from yesterday, and now we have this one. It's literally like a battle of the experts, is what it is. Well, of course, no, the DSM is used for medical billing as well, but it's not its primary purpose. Its primary purpose is diagnosis. Insurance companies use them for billing purposes. Yes, absolutely. I just, I don't know. It's always difficult when you have it's a one-person trial. They're on trial for murder. And, oh, thank you, Creative Expression. I got it when we were in Las Vegas. Dark Side of the Moon. Isn't it? It's a good shirt. I like it. Very good shirt. Thank you. It's difficult. It's difficult. Because mental health is invisible. You can't just point to it and say, there it is. One day we will be able to do that. I mean, we already have computers that can auto-generate an image that you are thinking about. Like, let's say you are thinking about a person sitting behind a desk, and the desk is brown and the person's wearing a white shirt and black pants. A computer, as you're imagining it in your mind's eye, if you're hooked up to electrodes, the computer can actually generate that image, a rough sketch of it on its computer screen, which is terrifying. That how far we've come. Like, thoughts are no longer protected. Your thoughts can literally be extrapolated. It's unbelievable. But we knew this day would come. It's not like a surprise or shock to anyone. And this technology exists. It's already out there. I've seen presentations on it. We are not far from literally living in Minority Report, where people are going to be prosecuted for crimes they were thinking about committing. They haven't even committed the crime yet. So right now the prosecution is putting on this psychiatrist to try and debunk what yesterday's psychologist said. And what I like about this is that they're putting on the psychiatrist fairly quickly in relation to uh, the defense's witness. So now the jury gets to hear them like back to back, and they get to decide who they believe more and why. Which I think honestly both of them are not very credible. You can't just have 9 sessions with someone and know everything about them and testify about it. Nor can you have 1 session. That's even less. I mean, sure, she's more credentialed. Fine. I'll give her that. She's got a medical degree, whereas yesterday's woman just has a college degree and a master's probably in psychology, because they weren't calling her doctor, that's for sure. Or were they? No, yes, they were. What am I saying? So she might be a PhD. She might be a PhD. They're merely hired guns. That's the best way to put it, Thomas Fisher. They're hired guns. They're trying to bolster their case because they don't have anything else. You have your facts, and you're trying to present to the jury that the person before you suffers from such and such illness, mental illness, or you know, um, do I think she has seen all the papers from jail? You talking about the expert? Maybe, maybe not. I don't think that has been confirmed or denied. The defense might jump on that. The prosecution hasn't really opened that Pandora's box, nor do they really want to. I mean, they want it cut and dry, which kind of makes sense. The defense is going to ask some good questions, I hope, because there is a lot of opportunity here. I mean, this woman testified to some very specific, like, diagnoses, you know. I don't believe she has PTSD is a pretty strong statement. And I think as a defense attorney, it's your obligation to rip her apart. I think the jury is going to have the lesser included manslaughter to decide on. The prosecution was smart enough to include the lesser included as well. I think the defense argued for it, and I don't think the prosecution is going to object, but we'll find out later today. Because if they move forward on just pure murder, I think they're going to lose. It's possible. It's actually possible. So as a prosecutor, you want to go forward just in case you get like a sympathetic jury. You go on murder with the lesser included manslaughter too. According to Google, the max on manslaughter 2 in Florida is 15 years. Somebody asked what's happening right now. Right now, there was an objection.
Members of the jury, thank you so much for your patience. I have a matter I have to discuss with counsel outside of y'all's presence. It may take a little bit more time than just our conference up here, and we don't want to have y'all just hanging out waiting for us to figure out what we're going to do next. So I appreciate your patience. We're going to excuse you to the deliberation room at this time. Please do not conduct any independent investigation or research as to the person, places, things, or charge involved, and do not have any conversations amongst yourselves or anyone else about those things, and we'll bring you back in as promptly as possible. Thank you.
The last one, yes, go on. If the prosecution revoked it, they can delete it.
Y'all can be seated. Thank you. Mr. Rowan, see if you can find me that portion of the transcript that we were addressing as to additional opinions and other depositions,
I do
and
like
anything in Dr. Warner's deposition that you believe we need to address regarding this opinion as it relates to PTSD.
Well, and Judge, it applied to every opinion she was going to express. It started on page 37, line 24, as it relates to Sarah Boone, do you have any diagnosis as it relates to her? And then 38 is when she started talking about a generalized anxiety disorder, and that she was not for sure whether Sarah Boone had a generalized anxiety disorder versus if it was just an adjustment disorder to being in jail. And then she also mentioned in that same answer that Sarah Boone had some narcissistic personality traits, and that those were my two major diagnoses. And then I questioned her further about that. She explained again on line 17 about general anxiety disorder versus the adjustment disorder, and that I hadn't had time to fully formulate that opinion of it. Line 21, I need time to go through my notes and think about it and process it.
Page. We're still on page 38?
38, line 21. I need time to go through my notes, think about it, process it. But I had the other depositions, as you're aware, yesterday, so I had to prepare for those and go through that. So I have not had time to process all my notes. And I said on line 39, well, doctor, I'm trying not to inconvenience you. You know, we're set for trial October 7th for jury selection. Line 6, I anticipate your testimony would be until a little later. So we could discontinue the deposition and then reset it when you've got time to review. Because obviously I'm not going to want to take your deposition and you have other opinions that are not going to be covered. And then I asked, looks like Mr. J asked, what's your position? He said, conducting discovery after the jury trial starts is completely unacceptable to me. So that's my position. If she needs to issue a supplemental report, or if there has become a need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once a jury is sworn and jeopardy attaches. And I say on line 23 of page 39, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnoses after she has had more time to think, review the paperwork, then obviously that creates an issue. And then she said, but if that happens, I can bring that forward, and then you can add to your deposition at that point if my opinions change after having reviewed further. And I referred to Mr. J. Page 9 of 40, Mr. J says, I think we plow ahead. This is our time with her. Court reporter's prepared to give us a transcript by the end of the week. Something needs to be amended.
End of the weekend.
End of the weekend. If something needs to be amended, then she can A, issue a report. B, if we need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition today, that is set for 3 hours, and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. Then I respond on page 40, line 23. I'm not suggesting that, Mr. J. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnosis or opinions. Mr. J responds on line 4. Okay. What I'm understanding her to say is right now, there has been a previous diagnosis of an adjustment disorder in some of the records, and she just needs to review her records to see if she thinks that is the best diagnosis that she would give as opposed to a generalized anxiety disorder. And then the witness says, you essentially flipped that, Mr. J, upside down. You got that backwards. So we go on to page 42. Line 1, Mr. Owens, I agree. And Dr. Werner, just let the state attorney know.
Okay, but we're skipping a massive portion of 41
Okay,
that addresses specifically opinions
let me go back.
as it relates to generalized anxiety disorder.
Okay, the witness starts on line 15. So she's saying she has the generalized anxiety disorder, and I'm saying I want to review it more. Because Sarah Boone had disclosed to the doctor that she had been previously diagnosed with a generalized anxiety disorder. And so the Dr. Werner was considering that admission, but she was saying, I want to review it more to see if I think it's more of an adjustment disorder to being in jail, Judge, to being in the correctional setting right now, and that the stressors that she is under right now as opposed to a generalized anxiety disorder. So Mr. J says on line 22, okay, so on this topic, if something new comes up, then we can address it. But if you have other topics to depose her on, then I suggest we go on. And then page 42, line 1, that's when I say, I agree, and Dr. Werner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot, and formulate any other opinions, just let the state attorney know, and I will address it.
We'll address it.
And we'll address it. Line 7, the witness, Dr. Werner says absolutely. And then, do you want me to continue reading, or?
If there's portions you want to highlight for me, I mean, I have the transcript. I'm following along with you.
That was the general understanding that we had about all diagnoses, all opinions that she may have. And so she starts talking about the mental status exam that she gave her, and then she page 43, line A, she said she has narcissistic personality disorder traits. Or I asked that question. That's how she answered. She goes through a little bit of that. And then paraphrasing, she talks about the grandiose component or criteria that she met. And then on page 45, I asked her what other criteria, on line 1, would tend to indicate that she was a narcissist. And the answer by Dr. Werner, I didn't say that she was. I said that she has narcissistic traits. And that was the examples. That was,
Excuse me for interrupting, but can we lasso this back into?
I understand that's what the depo reflects, but the non-objection which led to objection pertains to an opinion specifically about post-traumatic stress disorder. And as this time, no opinion is being referenced, nor does the call of the question pertain to narcissistic personality traits or a diagnosis of narcissism. The question pertains to PTSD.
all right, page 46. Line 1, question, okay? Do you feel like she suffers
getting
from
frustrating.
post-traumatic stress disorder? Line 3, answer. She didn't give me criteria with regards to that. She discussed having fear and anxiety of his family and fear that they would come into the jail or have someone else come into the jail and harm her. She talked about that. And she spoke about, having recollections, remembering abuse from George during the evaluation. Question 13, line 13 on 46. But you don't believe that she suffers from post-traumatic stress disorder, in your opinion? Answer, line 15. No. I would have to look back through my notes to see if she fully met the criteria. Question, line 17. Can you explain why you don't think she suffers from post-traumatic stress disorder? Answer, line 19. No, I didn't say one way or the other. I would have to look back through my notes for that. Line 21, question. Is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? Line 24, answer, I may. Number 25, question. Okay, and that's something you will let the lawyers know about if that changes? Answer, line 2 of page 47, yes. That's specific to the post-traumatic stress disorder.
Okay.
So at the time of this deposition, when I asked her specifically,
So what's the legal objection? What are the legal grounds of the objection?
I would not take that deposition, Judge. When she said, I have not had time sufficiently to answer these questions, these diagnoses, these opinions, if this wasn't set for a definitive date that you had already told me it's not going to be continued, I would refuse to take that deposition. But under the promises from the state,
What
I
are
will
the
be
legal,
notified of
what are
any
the
changes.
legal grounds of your objection? I'm familiar with the background. I'm familiar with the time frame. I'm familiar with all the dates and the depots and the coordination and everything we had to do to get this all teed up before trial. What are the legal grounds of your objection?
Come on, defense attorney.
I understand the backdrop.
I don't know if there's a legal ground other than we had an agreement as attorneys, as parties, that I would be notified of a change of opinion and I would be allowed to take a second deposition. That's the only thing I know to object to.
Okay.
Because I was not given that opportunity, which was an agreement between the parties.
Response.
Judge, I don't appreciate the implications that they're making.
They're
What I would proffer
state.
with this witness is, we spoke yesterday. I asked her if she had any change in her opinion about any of the diagnoses. She said no. And I asked, well, then my position, my understanding of her position is that it doesn't matter whether she had PTSD or not, because what Ms. Boone said at the time was that she zipped Mr. Torres up into the suitcase. They were both laughing. And once he was already secured in the suitcase, she became angry and then did all the things that she did. My expected answers from the doctor, based on a very brief conversation yesterday and this morning, was that if I asked her whether or not PTSD or BSS had anything to do with this particular case, that her answer would be, it doesn't matter because of what she stated happened. I'm not asking her about her diagnosis of PTSD. I'm not going to be going into narcissism. I'm not going to go into whether or not she ever delineated the difference between adjustment disorder or anxiety, because my understanding of what she told me was that none of this matters. None of this matters because of what she said to us during the evaluation.
But the question was, and I may have to ask Madam Court Reporter to read it back, but my memory of what the question was is, have you formulated an opinion with regard to PTSD?
And my expected answer was, it doesn't matter because of what she said during the evaluation.
Okay. Unfortunately, that was not the answer that came from the witness. The answer was a
I understand that, but that's
definitive
not the
no.
state attorney's fault.
I'm not casting blame. I'm just going back over of what was asked and what was said. Okay.
Yes.
Judge, and that's his position, that post-traumatic stress disorder, that doesn't apply in this case, and that he, I'm sure, reflected his opinion to the expert. But that doesn't mean that that's my opinion, that post-traumatic stress does not apply.
That's irrelevant for the purposes of this argument.
So their discussions and him sounded like it didn't apply.
Okay, as an officer of the court, he just told me he spoke to the expert yesterday and the opinions hadn't changed. And the opinion that was offered at the deposition was, I'm not sure. And based on what he had proffered as to what he expected the answer to be, the answer was not going to be any different. It's not applicable. It doesn't matter because of what she told me. That's unfortunately not the answer that was given. So what is it that you're asking me to do at this time, Mr.
Your
Owens?
testimony
I'm asking,
on that subject?
I don't know if we need to proffer the entire testimony of this witness, because opinions and diagnoses have apparently changed. I think I have a right to take a second deposition
Oh, dear God.
before she testifies.
What other opinions, Mr. J, if any, are going to be offered by Dr. Warner?
May I just proffer?
Yes.
All right, you've been present for all this hearing, yes, doctor? Am I misrepresenting any of our conversations?
No.
All right. And so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of the case as the defendant relayed them to you, what would be your answer?
That it's not related to the incident as she reported it.
And if I ask you, therefore, if there were any prior instances of violence, would that change your opinion? What would your answer be?
No.
And if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening?
No.
That's it.
Judge, number one, she's given a legal opinion. Number two, it's a discovery violation.
Discovery violation?
What is the legal opinion?
That post-traumatic stress disorder doesn't apply in this case.
Dr. Harper testified it did, and that's what experts do.
Yeah.
I would like to have known that, and that was going to be her opinion before today.
No, I'm starting to see it. I think the defense is actually pulling its straws.
That's not a change in testimony. That's
Where is that a change in the
So you're
deposition?
going to have to read the whole transcript. I asked.
No. This is a 87-page transcript. You're objecting. You have the burden to establish your objection.
Give me a minute. I'll read through it and find where I asked her.
I mean, this isn't the first time I've looked at this deposition. The state provided it to me when we had the hearing on whether or not battered spouse would be permitted. The state provided specific highlights for me to look at. At no point in time did the defense say, look at this, look at this, look at this in her deposition when we had that hearing. So other than what's being provided to me right now and what's been testified to this morning, I don't know what opinions she has. All I know in coming into today is what the basis of her opinion was, specifically with regard to any of the statements that Ms. Boone had provided, which was the whole crux of the state's motion to prevent battered spouse from coming into evidence.
Judge, if you look at page 66, line 20. Let me know when you're there, Judge.
Hang on.
This is getting spicy.
Yes, sir.
Page 66, line 20, question. Okay, so other than the couple of hours that you intend to maybe reflect on your notes and anything else, any other work that you intend to do on this case? Answer 23, no, sir. Not that I'm aware of. Line 24, question. And you've expressed all your opinions, at least generally here today. Answer, page 67, line 1. Yes, sir. Question. Then I go into fees. Then on 67, line 7, question. Just double dog sure. You admit that you have no other opinions other than the ones you've expressed here today. Line 10, answer. That I've been asked about. If I'm asked something else, that I'll offer it. Number 12, question. And you've been provided all the resources you need to rely on and express your opinions. Line 14, answer. I have based an opinion on the resources that I've been provided. If there's other things out there to be provided that may or may not change my opinion. I believe it's a discovery violation because I should have been notified if there was going to be a change in opinions. here today. And we had an agreement that I was gonna be allowed to retake the deposition and not be ambushed in the middle of the trial with a new opinion.
What new opinions are different based on what Mr. J proffered the testimony is going to be?
I have to ask Madam Clerk to reread the question and the answer from the expert. It's been so long now.
Madam Clerk, or Madam Court Reporter, are you able to reread the portion of the proffer as to what Mr. J asked of the witness? Absolutely. Of course.
PTSD. So, and if I'm understanding this correctly, she previously said nothing about whether or not she believes Sarah Boone has PTSD or not. Now she's saying she does not have PTSD. That's the testimony she offered in court today. I think it's improper no matter what. Forget the whole deposition situation. You should attack her on cross-examination and show that a 2.5-hour interview is bullshit and is not enough to provide a proper diagnosis. The jury will believe that. But the defense attorney is trying to backdoor and argue that the prosecution blindsided them, that the prosecution's expert never proffered this during the deposition, and now they're doing it in open court in front of the jury. So I think the defense lawyer has an interesting point, but I don't know if it's enough. Just attack her on cross-examination, dude. Practice your cross-examination skills. Show the jury that.
Court's going to step off for a moment while Madam Court Reporter is able to provide that reading.
2.5 minutes. 2.5 minutes. 2.5 hours is simply not enough to diagnose a person whether or not they have PTSD or not. That's the easiest route, in my opinion, to absolutely destroying this expert witness. I don't understand why the defense is arguing that the prosecution is being deceptive. Maybe because they don't have faith in their own cross-examination skills. Look, I may not be the best cross-examiner on the planet. I never would claim such a thing, but I definitely know how to deal with a witness that is reluctant to answer and is unwilling to answer. There's a certain art to it. There's a certain art to it. And the defense attorney needs to do a better job, I think, of showing that what this psychiatrist did with Sarah Boone is insufficient to provide an accurate, concrete, thorough diagnosis. I mean, hell, I would even go so far as to say, use your own facts, for God's sake. Like, look, would it be fair to say, doctor, that having 9 sessions with a patient is better than having 1 session? What do you mean? Well, in 9 sessions, you can get a broader and bigger picture of a patient than having simply 1 session with them, correct? I suppose, yes. And over the course of 9 sessions, you can get a more wholesome picture of what an individual's mental state is, because you get a longer timeline with them. You get to spend more time with them, and you get to see them over different periods in different days, correct? Correct. Boom. Come on, how difficult is that? That's not hard. Use your own expert, because a jury already knows that your expert spent 9 sessions with her, and they know this expert spent 1 session with her. Jurors are not stupid. They're going to understand this. I don't understand what the defense attorney is trying to win on like a technicality by maybe excluding what? Excluding this expert witness's testimony because they previously testified to something else? Does it really mean that her opinion changed? Or is she offering a new opinion? I mean, here's the other question. Can she offer a brand new opinion? Because what the judge kept asking, what is your legal objection? You know, objection, I've been blindsided is not a legal objection. Objection, the prosecution lied to me is not a legal objection. Objection, the expert changed her opinion between the deposition and now. I mean, that's a little bit different. But can she still do that? I mean, maybe she can. I've never had a situation like this before. So I have no frame of reference from personal experience, unfortunately. Otherwise, I would give you guys some guidance. 9 times, Carolina Rocker. 9 times. That's why I was in my little cross-examination sample that I just did. So no, it's not a Brady violation. Oh God, no. It's very simple. It's basically like the defense is saying the last time the expert witness testified, she didn't say anything about PTSD or she said something else, and now she's saying this. This is improper. That's basically what's happening, because they have prior sworn testimony of this witness in a deposition. Yes, depositions are sworn testimony. So you can actually impeach a witness. So impeach her. Why? Oh my God, I just realized what he's doing. Why is he not saving that for impeachment? Why is he arguing with the judge? Like, dude, just do your job. Yes. Impeach. He's trying to impeach a witness to the court. That's why you couldn't find the legal grounds for it. Oh my God, it's so simple. It was right in front of me. He's trying to impeach a witness to a judge rather than on cross-examination. And that's dumb. Let the jury be the arbiters, not the judge. The judge is sitting there like, what is your legal objection? Sir, what is your legal objection? I've been blindsided. The prosecution is like, we take umbrage with that. We take offense to this. I mean, I hate to say it, but how long has Owens been a practicing attorney? Let's see. James Owens. Attorney at law. His reviews are not all that great. He's got a 3.6 on Google. Oh, wow. You know, I never looked up these attorneys. Let's take a look. Can I make it bigger? Yeah, there we go. I pulled up all the 1-star reviews, so this is biased. I'm starting with the 1 stars. Spoke with him about a domestic violence case back when I was living in Santa Rosa. He seemed more like a used car salesman instead of a lawyer. Went with a more established firm and got a fantastic outcome. 100% would not recommend. Wow. I would never hire this lawyer after watching him work the Boone case. His strategy is pathetic and embarrassing and showcases. Okay, so this is not a client. This is somebody who has been watching the case. She man is an outright liar. I'm referring to Sarah. Okay, no. I wonder if his results are skewed because people are commenting about him representing Sarah Boone. Didn't want to speak with me in person, so he never heard all of my story. Too many clients, so he can make more money. He's a dollar store lawyer. Update. Do not hire this man. All he's going to do is make you take a plea deal. Probably pretrial. Wait, what's PTI? Pretrial investigation. Make you pay more money after all the money you paid him in case you had to go to trial, which you were not. Oh, my camera disappeared again. What the hell? Hold on, folks. Technical difficulties. Mi scusi. What's going on? Okay, there we go. Sorry about that. I don't know what's going on with my camera today. Hopefully it doesn't jack up the audio when court resumes. We're still waiting. I have the court in the background. We'll hear it when it comes up. Okay, so do not hire this man who's going to do that. Message me, I'll explain. Don't waste your hard-earned money on this incompetent, unprofessional guy. You will be pushed to take a... Okay, so that answers all the questions I had. You know, why isn't this guy doing a proper cross-examination? Because he's not used to it. He doesn't do cross-examinations. He doesn't take cases to trial. He pleads clients out, according to some of his reviews. You will take a plea deal. You'll be pushed to take a plea deal. That's even worse. You will have to do the job his investigator should be doing. You will write up your own defense. He's unprofessional and inconsiderate. I would never wish this horrific representation and waste on my worst enemy. Damn. People just want an attorney that they can trust to do the job they are paid to do. I hope this helps someone find an actual good attorney. 1 star, 1 star, 1 star, 1 star. 2 stars. After a year working on my case, I was informed that he was closing the office to work on this murder case in Orlando. So he's throwing his current clients under the bus to go work on frickin' Sarah Boone? Are you joking? He's closing the office? Does he not have any associates? After a year working on my case, I was informed that he was closing the office to work on this murder case in Orlando and that I would need to find another attorney. I'm trying to get my records and all that we've done because we were towards the end of my case and I'm having a hard time getting them. Very disappointed. I'm an existing client and I don't feel like I ever mattered. You can't treat your clients like this. Oh, wait. Another Sarah Boone case. A Sarah Boone review. It appears that he took special notice of Sarah's bizarre circus flyer. Okay, that's just a Sarah Boone review. And then we got some 5 stars. So he's got some 5 stars. He's an excellent attorney. I was falsely arrested, 28 days from miscommunication. I was charged with 3rd-degree felony. He treated me well. The mere fact that Attorney Owens has taken on Sarah Boone's case in response to it makes me have immense respect for him. How can people review an attorney if they haven't used his services? Give the guy a chance. That's true. I do agree with that. I'm very impressed with him. So he's got some good reviews too. Like, He's got the rest are all 5 stars. You know, I'm not trying to just crap on the guy. So the reviews must be skewed. I wonder what his rating was before the Sarah Boone trial. It might have been like 4 point something. It's unfortunate. Let's go to his website. How long has this guy been practicing? 1986. So 2 years before I was born, he was already practicing law. He's going to be practicing for 40 years in like a year. DUI, murder, armed robbery. No case is too complex. Now, I found this interesting. James Owens' true motive. Apparently, he did an interview for Court TV a couple months ago. He was asked directly, "Are you doing this pro bono?" He said, "No, Sarah will have to pay me at some point in the future. I've had clients in the past who just pay me back in $50 monthly installments." What? $50 a month? What, for the rest of their lives? You know what a nightmare it is to be chasing that? I used to do like $500 a month until paid in full back when I was a younger buck and I had fewer clients. I can't do that anymore. It's impossible. People just, they forget. They're unavailable. It's hard to reach them. I hated it. $50 a month for what, 9 years?
2020 CF 2603, State of Florida versus Sarah Boone. State.
Dave Castro on behalf of the state. William J. for the state.
Defense.
James Owens, Ms. Boone.
Kevin Beck, on behalf of Ms. Boone.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. Madam Court Reporter, have you had the opportunity to review the transcript as to the proffer of Dr. Werner's testimony? Okay, you may proceed.
By Mr. J, question. You've been present for all of this hearing, yes, doctor? Answer, yes. Question, am I misrepresenting any of our conversations? Answer, no. Question, all right, so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as a defendant related them to you, what would be your answer? Question, that it's not related to the incident as she reported. Question, okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. Question, if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
I don't think that's the very beginning before I objected.
What was asked was to read back the proffer.
I thought I was asking to go back to the very beginning when the question was asked and then her response and my objection to it.
What was specifically asked was to the proffer, because the question before the court was whether the proffered opinions are at odds with what was testified to during the course of the deposition. There's the question that was asked and the answer that was given affirmatively provided an opinion as to PTSD. I think Mr. J admits that. Mr. J has advised the court that's not what he was hoping the answer would be. The answer was supposed to be something different as identified in the proffer, which is why I had Madam Court Reporter read back the proffer. So the question Mr. Owens posed to you is whether the proffered opinions that Madam Court Reporter just read back to us are different than what was provided in the deposition.
Yes.
How so?
She tended to explain in the proffer some legal reason why why it did not apply in her opinion. That was not discussed in any way in the deposition.
So
My question is
cross-examine
specific
her,
as to
not job.
opinions. Her opinions were as to battered spouse syndrome or post-traumatic stress disorder and their relationship to the case based on the defendant's responses. The answer is not related to the incident as the defendant reported. Those are the opinions, as I understand them, based on the proffer, as it relates to battered spouse syndrome and post-traumatic stress disorder.
The judge should be like, look, this is a matter for cross-examination. End of story. Move on. He's trying to get her testimony stricken. Yeah, Thomas. Or something. Excluded, stricken, make the jury ignore her. Like, this is so unnecessary. And I think it's frustrating everyone, the witness, the judge, the prosecutor. By the way, this guy claims to have
You can
tried
refer to page 46.
over 100 jury trials to
19
verdict.
is the question, but you don't believe that she suffers from post-traumatic stress disorder in your opinion. On 15, the answer is no.
I wonder how many of those were traffic ticket trials. I'm serious.
See if she fully met that criteria. Question 17, can you explain why you don't think she suffers from post-traumatic stress disorder? Line 19, answer no. I didn't say one way or the other. I would have to look back through my notes for that. Question number 21, is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? 24, I may. 25, okay, and that's something you will let the lawyers know about if that changes. That's on page 47. On 2, yes. That's fundamentally, substantially, materially different from what she's testified as it relates to post-traumatic stress as it applies in this case.
In the proffer?
Excuse me?
In the proffer? She's not rendering an, unless I misunderstood the proffer, she's not rendering an opinion on PTSD and whether or not Ms. Boone suffers from it.
Well, she led me to believe that she was trying to decide whether or not Sarah Boone suffered from post-traumatic stress. Now in the proffer, they're claiming that post-traumatic stress does not apply. I don't know what the initial question was. We haven't had that read back. When it was first going on, when a question was asked, and I believe she rendered an opinion, and I, again, like that to be reread back. What the initial question was, what the response was, because it didn't, I know I objected, I can't even remember it now, but I know I objected because I knew.
Oh my God, he doesn't even remember.
You asked to approach, and then you explained that the question was it was not something that was framed in the deposition. Multiple times I asked you for a legal objection. And it wasn't until right before or right after we sent the jury out that you provided some legal objection. You know, Madam, if you want Madam Court Reporter to go back and read the question that led us to where we are right now and the answer, I'm totally on board with that. I have a memory of what it was, but nothing like.
Before she does that, can I get the first question of the proffer? If BSS or PTSD has any, can you reread that? So
Let's just reread the entire proffer, just so that it's a clear soup to nuts, alpha to the omega, what the proffer was. Madam Court Reporter, if you could be so kind. Yes, ma'am.
By Mr. J, question. You've been present for all of this hearing. Yes, doctor? Answer, yes. Question. Am I misrepresenting any of our conversations? Answer, no. Question. All right. So if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as the defendant relayed them to you, what would be your answer? Answer. That it's not related to the incident as she reported it. Question. Okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. And question, and if you reviewed any of the materials or materials Would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
And then if she could go back to the initial,
Claims he has tried over 100 jury trials. Mr. O. The court reporter is going back right now. Try and find the portion of the testimony where the defense objected.
I'll wait on you, please. Go ahead.
Sorry. Pay no attention to me. Go ahead. My understanding is it was the question and the answer right before Mr. Owens asked to approach.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the
Right.
time that I evaluated her at the jail.
Can you read that for me one more time, please?
The answer.
Both the question and the answer.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
Maybe we please have the previous question as well.
Question, and in this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening? Answer, I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change. Question, what was your opinion?
Mr. Owens?
number one, that question and answer, she gave a differing opinion than what she gave in her deposition.
So cross-examine her.
To the agreement we had, I should have noticed. Number two, with the proffer, it seems that she's going to find that post-traumatic stress disorder did not apply to the facts as related by Sarah Boone. And that is an opinion that I needed to know about. And I asked throughout this deposition and at the very end, some general, if you have any new opinions or anything new that differs from what you've said here today.
So she lied to your face and get to her on cross-examination.
Right to be prepared for the trial through discovery to know what the witnesses are going to opine. And this is a discovery violation based
Oh
on
my God.
two things. One, her initial answer to the question that I objected to, and then two, the proffer is a new opinion. It's a discovery violation. I ask that the witness be stricken.
Any response?
Judge, I think it's clear from my original question that the intent that I stated was the intent of my question, to get the answer that I intended to get, was what the question was intended to elicit from the witness. As far as the discovery violations and continued attacks, I'm just not I'm not convinced he understands what the answer means or what it's going to be. The answer isn't going to be Ms. Boone didn't have PTSD, hence, therefore, battered spouse syndrome doesn't apply in this case. What I believe she's going to say, and what I believe I've been saying she's going to say, based on our conversations, was irrespective of whether anybody believes Ms. Boone had BSS or PTSD, it is irrelevant because of what Ms. Boone told her happened at the time of the event. That is not a discovery violation. She was specific in saying, if you have any questions you want to ask me, I'll give you an opinion. That is exactly what she said on page 67 of the deposition in response to a question that starts at line 7. Question, just double dog sure, you admit that you have no other opinions other than the ones you've expressed here today. Answer, that I've been asked about. If I'm asked about something else, that I'll offer it. They didn't ask about the interplay of the facts with the relevance of the syndrome. That's them, not the state.
Any other argument?
The totality, if you read that deposition and all that we talked
I
about-
specifically asked you, Mr. Owens, to point out for me
I'm
what,
pointing out,
excuse me, I specifically asked for you to point out specific portions of the deposition that are at odds with either A, the opinion that was previously given, or B, what was proffered to. You have provided me pages 45, 46 of the deposition relating to specific opinions on whether or not Ms. Boone suffers from post-traumatic stress disorder. Are there any other portions of the depo that you would like to point out for me? I am not going to read an 87-page deposition and continue to waste our jurors' time as we try to find a solution for the situation that is now before us. If there are specific portions of this deposition that are at odds with the opinions that have been proffered and or provided so far, I would ask you to direct my attention to them,
well, the ones that I expressed.
other than what you've already identified.
The ones that I expressed, and that just the understanding that we had, that she, in the pages that I have talked about previously here today, in the pages that I referred to about our agreement, that she was going to let me know if there were any opinions that she had.
Just do it on cross-examination, buddy.
Thank you. All right. Any other argument, Mr. J?
No, thank you.
Okay, thank you very much. All right, the court has had the opportunity to listen to the proffer as read back by Madam Court Reporter, the read back of the opinion that was previously offered, the portions of the deposition which have been highlighted by the defense specifically pertain to opinions by the defendant as to whether or not the defendant suffers from post-traumatic stress disorder. That opinion is not being offered. The opinion pertains to the relationship of battered spouse syndrome and or PTSD as it relates to the facts of the case as the defendant has relayed them to you, and that they are not related. However, the deposition is identified by the defense, identifies that if there were any additional opinions, that there would be notification. So the court at this point in time as there has been an alleged discovery violation in accordance with binding precedent by the 6th District Court of Appeal, which is binding on this trial court in Young v. State, 369 Southern 3rd, 1243. At pinpoint 1248, the court is now going to conduct a discovery violation or discovery Richardson hearing. State any other arguments with regard to the elements of a Richardson hearing?
No, sir.
Okay, thank you. Any other arguments with regard to the elements of a Richardson hearing, Mr. Owens?
None other than I understood she did give an opinion about post-traumatic stress in that initial.
Okay, we're going to do it here.
Okay. All right, the court, again, reviewing the proffer and the opinion, finds that the state's violation was inadvertent based on
There you
the
go.
proffer by the state, which was agreed to by Dr. Werner as to the conversation they had last night, as to the opinions and whether or not that they had changed. However, I do find that that violation is substantial with regard to the opinions based on the testimony in Dr. Werner's deposition that any other additional opinions would be notified to the defense.
Oh, what happened?
As it relates to the third category, the effect on the defendant to properly prepare for trial. Although the questions in the deposition as highlighted by the defense so far do not address the opinions being currently offered, I do find that it had some impact on the ability for the defendant to properly prepare for trial. As it relates to the opinion that was previously provided as read back, specifically my opinion was that she did not give enough information to diagnose her with PTSD at the time of the evaluation at the jail. What is your position, if any, with regard to that opinion now that the jury has heard it? Mr. Owens.
Wow.
Because my question is, do you want it struck?
On that issue, we'll address it on cross-examination.
So you are,
Oh my
you do
God,
not want
finally.
it to be struck, and you do not want a curative instruction.
Well, I'm going to question her about post-traumatic stress, so it's going to come
Oh
out.
my God. Dude, you just got your W.
The deposition about what she said.
Just-
It's inconsistent with what she said here today, so I'm going to want.
He's not even he doesn't know how to win.
Okay, all right. Ms. Boone, have you been paying attention to the questions and answers and the readbacks of both the proffered testimony and the opinion testimony?
Yes.
And are you on board with the strategy not to seek to strike that opinion?
Yes.
Thank you.
Why did you object then? You objected.
With regard to the proffered testimony, I'm going to
And then you
permit
surrendered.
now in open court, and I will oversee the deposition for you, Mr. Owens, to inquire as to those opinions.
I'm sorry.
With regard to the proffered opinions,
He
the
doesn't
court
know
will
anything
oversee
about
a deposition now, and you may proceed.
Right now?
Yes. With regard to the proffered opinions.
Right now?
And I believe that will provide a cure for the discovery violation under the Richardson violation based on your request not to strike the prior opinion. And since you're going to utilize that on cross, I find that the prejudice is limited. But with regard to the new opinions, I will give you the opportunity to depose her now, curing the prejudice at that point in time.
Oh.
You may proceed.
Dr. Warren,
Yes, sir.
good morning.
Good morning.
At some point, the state attorney notified you that you were to come today.
Correct.
Did you and the state attorney have a discussion about your testimony?
Yes.
When was that discussion?
Briefly last night.
So y'all talked on the phone last night?
Yes.
Have y'all had any discussions since the phone conversation last night?
Briefly this morning.
And how long was the phone conversation?
Less than 5 minutes.
How long was the face-to-face conversation?
Less than 5 minutes.
Did y'all discuss that your testimony would be that you did not have enough information that you gathered from Sarah Boone to form an opinion as to whether or not she suffered from post-traumatic stress disorder?
Correct. That my opinion hadn't changed.
I'm sorry?
Yes, that my opinion hadn't changed, that I didn't have enough information.
Okay. And did the state attorney speak to you about that it didn't matter whether you had an opinion if you didn't feel like the facts that Sarah Boone had given you as it relates to the facts and issue in this case, that you didn't, if you didn't feel like post-traumatic stress even applied, then you could answer that way.
Correct. That was my opinion. Correct.
But did he present that to you initially for you to form an opinion about it?
No, my opinion was that it didn't apply because of the way that she described the incident to me.
Was that your opinion back when I took your deposition?
Yes,
When did you form that opinion?
when she described the incident to me.
Why didn't you let us know that was your opinion at the time that I took your deposition?
You didn't ask me about that, sir.
Do you remember me asking you any other opinions that you may have as it relates to this case?
You didn't ask me specifically about that.
I understand that, but you're saying you formed that opinion prior to the deposition, correct?
Yes. The state attorney and I discussed that on the way out of the jail, as a matter of fact.
After the deposition?
No, sir. After the evaluation.
Okay.
On the way out of the jail.
All right. And I asked you, were there any other opinions that you may express at trial after you had discussed that with the state attorney prior to the deposition? Is that correct?
Yes.
And so you were aware that I didn't want to be ambushed at trial. I wanted to know any and all opinions that you may be expressing in the Sarah Boone case.
I didn't know what specific information you wanted, sir. That's why you had a deposition. I answered your questions. I don't know what all information you want me to provide to you.
So because I didn't ask you specifics, you felt like you didn't have to respond specifically.
No, sir, I answered all of your questions. And as I said, I'm happy to answer any questions that I'm asked. I don't know what questions you want me to answer.
But you know that this was a central issue in the case. Did you not? Your opinion
Yes,
is relating to a central issue in this case.
correct.
You're aware Sarah Boone's on trial for murder.
That's
And you had this opinion when I was taking your deposition, and I was asking you specifics about any opinions that you may be expressing in the trial of Sarah Boone, and you did not disclose it.
well, I told you that I would answer any questions that were asked of me. I have a number of opinions. I know that I don't feel that she's suffering from major depressive disorder. I didn't offer that opinion either. I have a number of opinions.
That's all the questions I have.
Mr. J, anything else?
I'm just making sure he doesn't want to inquire,
This is your opportunity, Mr. Owens.
because that was more just about.
Inquire about what?
This is your opportunity to inquire. You are conducting a deposition. This is your opportunity and your only opportunity to cure any prejudice that we've identified with regard to those proffered opinions as it relates to the relationship of battered spouse syndrome and or post-traumatic stress disorder as proffered.
The problem is now, Judge, is I've got my expert, and we weren't aware. You know how in these type cases, the experts are allowed to listen to the testimony of the other experts and read the depositions of the other experts. Dr. Warner, were you given the opportunity to read Dr. Harper's deposition?
I was.
I mean, that's standard operating procedure in these type cases. And now I'm taking a deposition on the fly, and then I haven't had a chance to speak with my expert about those opinions and whether or not that would change her opinion.
You can't
It
accept
just puts
the
me in a very difficult situation, but if I'm ordered to continue the deposition, I will.
That's your decision. It's not an order. I'm just saying that this is the opportunity to cure that Richardson issue. You asked previously to strike the expert. I am disinclined to do that. The case law says that is an extraordinary remedy, one which I am not going to permit.
Dr. Warner, you realize you're in a courtroom
Yes, sir.
and we're waiting on the jury on the trial of Sarah Boone.
Yes.
Are there any other opinions that you intend to express in this trial that you have not disclosed to me in the deposition or you have not disclosed here today under oath?
I'm happy to answer any questions that I'm asked.
Are you refusing to answer my question about any other opinions that you intend to express here today as it relates to Sarah Boone, who was on trial for murder in the second degree?
Judge, I'm going to object. The catch-all vague question that Mr. Owens wants to ask this expert witness about any and all opinions she may or may not have, 99 out of 100 attorneys would come in here and say, that's not how you do depositions with expert witnesses. You have to ask specific questions. Anytime you ask a question like that of an expert, the expert's always going to say, please ask me a specific question. And that's what she did then. That's what she's doing now. It's unfair and vague to ask somebody, tell me every opinion you have.
Owens is just not the
Judge,
Yes, sir.
we're in the middle of a trial. She's fixing to testify. She's had conversations with the state attorney. She knows what she's going to be asked in terms of opinions that she's going to express.
Use it on
That's why
cross.
she's
You've
here,
never offered
to
this
help the
before.
jury
This is
understand
you're ever saying
the
this
science
stuff.
that
Oh my
relates to the
God.
law and express opinions. I mean, for me to ask, we're playing hide the ball here? In the middle of a trial,
I disagree that there's any hiding of the ball. There's been a proffer that's been read multiple times as to the scope of the opinions regarding to battered spouse syndrome and post-traumatic stress disorder and its relationship to the facts of the case as the defendant represented them. And the answer is they are not relatable to the incident
I
as
remember my
relayed
first
by
trial.
the defendant.
Jeez.
That is the opinion that have been proffered.
all right, can I continue with my deposition?
Yes, sir.
Dr. Werner, do you recall expressing that you wanted more time to reflect as to whether or not Sarah Boone suffered from post-traumatic stress disorder?
Yes, that I was going to review my notes to see if I had enough information in there to support or negate that.
All right. What additional information would you need for you to express an opinion that she suffered from post-traumatic stress disorder?
So she did not give me information regarding the presence of intrusive symptoms. She didn't give me information regarding persistent avoidance. She didn't give me information regarding alterations in arousal or reactivity.
Anything else?
No.
Would you agree you failed to ask her those questions?
I asked her if there was any other important information that she felt like she needed to share with me at the end of my evaluation, and she said no.
So a catch-all question.
Correct.
Were there any other personality disorders? Isn't that what you do as a psychiatrist? You diagnose an opinion, express opinions about whether people suffer from personality disorders?
Correct.
Are there any other personality disorders that you have formed opinions about Sarah Boone that you intend to express?
No.
So
There you go. That's a better question.
narcissism, you did not find.
I found narcissistic traits.
In terms of your opinion that she suffers from narcissistic personality disorder.
No, sir, I said narcissistic traits.
Okay. So you don't have an opinion that she suffers from narcissistic personality disorder.
Correct. She displays narcissistic traits.
You expressed an opinion that she suffers from alcohol use syndrome,
Alcohol use disorder.
alcohol use disorder.
Correct.
Is that still your opinion?
Yes, it is.
Anxiety disorder. Is it your opinion she suffers from the anxiety disorder?
No.
Do you recall in your deposition indicating that you felt like she suffered from either anxiety disorder or adjustment disorder?
That's correct.
And you've changed that opinion now?
I have, I'm leaning towards the adjustment disorder secondary to her legal situation.
So you haven't formed an opinion as to whether or not she suffers from general anxiety disorder or adjustment disorder?
Correct.
You agree that she suffered from trauma as it relates to the domestic violence history that she expressed to you from the intimate partner violence with George Torres?
Yes, as reported by her. Yes.
Do you have anything to dispute that?
No.
In your opinion, does she suffer from any form of psychosis?
No.
Is it your opinion that Sarah Boone suffers from acute stress disorder?
No.
Is it your opinion that Sarah Boone suffers from intimate partner violence?
Yes, I think that there is enough history of the volatile relationship between the two of them.
Because of that, do you believe that Sarah Boone suffers from battered spouse syndrome?
She may meet the criteria for that.
May. So it's possible?
Yes.
Is that your opinion?
Yes.
Definitively, you can't say?
There's a history of her having that. Yes.
So you agree she suffers from battered spouse syndrome?
Yeah.
I believe we've covered anxiety disorder, narcissism, battered spouse syndrome, and alcohol use disorder. Are there any other opinions that you intend to express as it relates to that or any other psychological condition of Sarah Boone?
No.
That's all the questions I have.
All right. Finally. Linda, thank you for being
Any other arguments
Welcome back.
at this time?
No, Judge, just the one I've already made.
Okay, all right. The court has conducted its Richardson hearing and made its findings. The court, as previously identified, will not strike the expert as that remedy is quite draconian, and I will not do so based on the questions that were asked as highlighted by the defense and the opinions that were offered. The specific areas for which opinions are being offered were not inquired into, but the deposition did leave it open that I'll ask questions about any other opinions that I'm asked about or anything else that I'm asked during the course of the trial, specifically page 59, 22 through 26 on 1, page 60, lines 11 through 25. So in the abundance of caution, the court has permitted that in-court deposition. Anything else, sir?
No, sir.
State, anything else?
No, sir.
All right, let's go ahead and bring back in our panel and we can,
Before we bring the jury back in, may I approach Mr. Cacciatore on a completely unrelated matter?
does it need to be on the record or?
Yes, it does.
Okay, go ahead.
We would concede that Detective Copsell and Detective Lowen are not testifying against us here in court this morning.
They're still under defense subpoena.
I
We have
asked,
not,
I asked Mr. Henderson if you guys were calling Detective Capsule again, and he said no.
and we're not in our defense, our direct defense. Is there a possibility that based upon the information the state is going to present today or this afternoon, that we may want to receive or seek rebuttal and possibly through these witnesses? They're under subpoena, and I'm sorry, Mr. Henderson's not here. I've just noticed their presence. Out of an abundance of caution, I think that we need to clarify for the record that they're here listening to.
What's your base? Well, we're off the record. There's no jury here. That's fine. You all stay where you are. What's the basis for your sir rebuttal?
We don't know because I don't know what the state's going to place in rebuttal. But
It doesn't answer my question. What's the legal basis of a sir rebuttal?
Judicial discretion as to the fairness of the proceeding that the defendant pursued.
Okay. Anything else, Mr. Cacciatore?
No, Your Honor.
Okay. The rule sequestration is still in full force and effect. Detectives Lowen and Kepsel, good morning. I'm going to ask you to be excused from our proceedings and not view them and not have any communication amongst yourselves about testimony that has been previously given or any questions that have been asked or answered, and just keep your separate ways as it relates to this case and any questions or testimony that you intend to give, may give, or have give, and to comply with any instructions that were provided to you by the state regarding the rule of sequestration. Thank you very much.
This doesn't feel like a real courtroom. It's like mock trial.
Anything else, Mr. Owens, we need to address?
No.
Anything else, state?
No, Your Honor.
All right, let's bring back in our jury. You can continue your inquiry, sir.
So many rudimentary rule violations. It blows my mind.
Bless you.
I like how the captions are. The hamster doing the CC today. It's extra fun.
Jury's entering.
But certain things have to be handled outside the presence of the jury. Like proper testimony. Like,
State, you recognize our jury.
Yes, Your Honor.
Spence, do you recognize our jury? I thank y'all. You can be seated. Members of the jury, thank you again for your patience. We had some issues I had to address with counsel outside of your presence, and we're going to continue the state's rebuttal case this morning. Again, if you could, please just raise your hands to confirm that you complied with the court's instructions during the break. Record reflect all hands have been raised. Mr. J, you may continue your inquiry, sir.
State would move to strike the last response as non-responsive.
Approach.
what? The state would like to move to strike the last response is non-responsive. WTF is happening? What does that even mean? The last response, the PTSD, you could not diagnose her. PTSD, no, I did not have enough information. Moving to strike is non-responsive. I'm going to re-ask the question, I guess. Do I sound like I'm miles away? Somebody said?
Your objection's overruled.
Thank you.
Irrespective of whether anybody has an opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that, based on your evaluation of Ms. Boone and what she relayed to you about the facts of the case, does PTSD or BSS have any relation?
Objection, that's an asked and answered.
Overruled.
No.
And what particular part of her statements about the incident is that?
The whole part where she's describing the part about playing hide and seek and that they were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him up. They were still laughing, you know, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent, you know, there was an imminent risk of harm that she was.
Oh,
Yes.
that's good. That's good. And the defense, like, you can see even the witness is frustrated because it's like, dude, she's an expert. She can offer her opinion. If you don't like it, cross-examine her. What are you trying to object for? All you're doing is you're highlighting to the jury, hey guys, this testimony really, really hurts my case. This really hurts Sarah Boone. We don't like it. All they're doing is they're letting the jury marinate on this information even more, rather than just like boom, bing, bang, boom, get in, get out, do a cross examination, show that you can't determine this in 2.5 hours and call it a day. Of course, she was not in any imminent danger, but you can show that in 2.5 hours you can't determine that. That was not enough. Fix it on cross and then solidify it in closing argument. The way that this defense attorney is trying to do it through like constant objecting is just wasting the court's time and making everyone more and more frustrated. That's what happens when you don't know how to do your job. I'm sorry. Ugh. I am so annoyed. I thought this was going to be fun. I literally thought like, oh, prosecution expert, this is going to be great. But if you don't let her speak and you're constantly objecting every 15 seconds, no, it's not going to be a good time. Ay. Mad Dog, you're surprised that the idea of Sarah Boone having a split personality wasn't considered? That's probably because she doesn't have a split personality. She was intoxicated and she made a dumb choice. She chose not to take George out of the suitcase. There's no split personality here, but in my humble opinion, she's not Amber Heard. Amber Heard probably has some sort of split personality when she becomes manic or whatever. We've seen evidence of that. But Sarah Boone, no. It's just that when she was drunk, she decided to make a bad choice. She left George in the suitcase, which is extremely inhumane.
Members of the jury, I have something I've got to discuss with counsel outside of y'all's presence. Same instruction. Please don't conduct any independent investigation or research on the person, places, thing, or charge involved, and don't have any conversations amongst yourselves or anyone else with regard to that, and we'll bring you back in as promptly as possible. Thank you.
This is a shit show at this point. Oh my god. UI Kitty is right here. Hi, Zinnia. And it's spelled Zinnia.
Y'all can be seated. Thank you. Madam Court Reporter, when you're ready.
What is happening? This is just delaying the inevitable. That's all it's doing. The jurors come in, they listen for 5 seconds, and then they're right back out again. Zinni, are you trying to leave? Stupid cat closed the door. Now she's trying to leave and she can't figure out how. Use your paw. There you go. You can do it. Come on, Zinni. Use your claws. You can do it.
Yes, ma'am. Just go from, read it from the question, answer, question, objection. Let's just have we can buttress it.
I swear to
Go
God.
ahead.
By Mr. J, question, all right. Irrespective of whether anybody has any opinion about whether Ms. Boone is suffering from PTSD or DSS, irrespective of that, based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD or DSS have any relation? Mr. Owens' objection, asked and answered. The court overruled. The witness, no. Question, and what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part about playing hide and seek, they're having a good time, they were laughing. When he got into the suitcase, when she found him, they were enjoying themselves. She zipped him, they were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
Any other argument, Mr. Owens?
That invades the province of the jury. That's a decision whether or not she had imminent risk of harm or perceived an imminent threat is a question for the jury. This expert can express opinions on science, on medicine, but not on the ultimate issue of fact, and explain to the jury that this defense doesn't qualify, that you should rely on me as an expert, and I'm going to make the decision for you, ladies and gentlemen of the jury, by telling you that under the facts expressed to me by Sarah Boone, she was not perceiving an imminent threat at the time.
Response.
Judge, it's not an objectionable opinion. It's not an opinion on the ultimate issue. It's an opinion upon the applicability of a particular set of evidence that testimony that the defense has offered, called battered spouse syndrome, to kind of help explain a portion of the justifiable use of deadly force or non-deadly force instructions. She's not up there saying Ms. Boone was unjustified in doing what she did. She is not saying that justifiable use of force doesn't apply. What she is saying is, in her opinion, based on the facts that she relies on, given by the defendant herself just a couple of weeks ago, that this particular set of testimony and evidence that has been offered through their expert, Dr. Harper, doesn't apply. This is no different than one expert coming in and saying, well, yeah, you can know that the defendant was sane at the time, despite his mental illness, because he ran from the police, he hid, he concealed evidence, so on and so forth. And therefore, because of those facts, insanity doesn't apply. And a defense expert may come in and say, well, insanity does apply because my client, after stabbing her mother to death, called 911, was speaking unintelligibly and singing, and greeted the officers at the door with a pair of knives and wouldn't drop the knives and was incoherent for 12 hours after the offense. Therefore, based on those facts, the expert says, well, insanity does apply. It's not becoming a lawyer. It's not becoming the juror. It is explaining a particular type of expert testimony. And it just happens to disagree with Dr. Harper's. And Dr. Harper came in and said that BSS does apply and that she was in constant fear. And the reason she's in constant fear is because of all the past episodes and whatnot. It's permissible testimony.
Any other argument, Mr. Owens?
That's totally wrong. He claims, the prosecutor claims Dr. Harper came in and said BSS does apply. That's true. But he just got through saying and trying to get the witness to say BSS, it's not to be regarded. Post-traumatic stress is not to be regarded. It doesn't even come into play. Post-traumatic stress disorder, battered spouse syndrome does not even come into play because at the time she was facing, according to this witness, no imminent risk of harm. Therefore, you can discount everything you hear, ladies and gentlemen of the jury, about battered spouse syndrome.
How does that have anything to do with whether or not it's an improper legal opinion under 90.703?
It is. It's the ultimate issue of fact in this case because self-defense has been alleged by the defense. And the issue for this jury is whether or not Sarah Boone had the right to defend herself with force, deadly force or non-deadly force, based on her beliefs and impressions at the time, whether they were reasonable under the jury instructions, under the special jury instructions that are going to be applied for battered spouse syndrome, under the jury instructions, under justifiable use of deadly force, whether her perceptions about the threat was imminent and whether it was appropriate or reasonable to act the way she did. This expert is trying to say that she was not facing imminent risk of harm at the time.
Thank you both for your arguments. Court is going to overrule your objection, find that it is not an ultimate issue of fact as addressed by 90.703. Court specifically relies on Dinkins versus State 976, Southern 2nd 660 at pinpoint 661. In that case, a psychologist testifies in the instant case in Dinkins, the psychologist's opinions were not legal conclusions. The psychologist did not opine on the defendant's guilt or innocence. Rather, the psychologist opined only as to whether the victim was, quote, mentally defective, end quote, and capable of consent to intercourse. Although the opinions did go to ultimate issues in the case, Florida law, expressly provides that an expert witness may render such opinion, see section 90.703 Florida statutes, which provides that testimony in the form of an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact. Thus, the jury had the power to accept or reject the opinions and was not bound by such. For those reasons, your objection is overruled.
Madam Court Reporter, I'm just going to ask you to read the question and the answer, and I have no further questions of the witness.
Okay, thank you.
I'm sorry?
He is going to have Madam Court Reporter read back the question and the answer, and then he is going to have no other questions for this witness.
I object.
Basis.
To what?
It was asked and answered.
Overruled. There was a pending objection. I'm allow the state to re-ask it so it's clear based on that objection.
Judge, it's 11:30. I'm going to be at least an hour for my cross-examination.
We're going to begin your cross-examination after we're done with the state advises the jury in open court. There are no more questions. Let's go ahead and bring back in our panel.
This lawyer is showing his incompetence more and more today. I can't believe this guy's done over 100 jury trials. Like, if you told me 95% of the jury trials he's done are like speeding tickets, I would be like, checks out.
Where's Henry?
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? All right, you may be seated. Thank you. Members of the jury, again, if you could raise those hands. Juror number 2, back right, he gets it. All right, thank you all very much. Record reflect, all hands have been raised. State, you may proceed.
Request to read back the question and answer.
Madam Court Reporter.
Ah. Ah.
Question by Mr. J. All right, irrespective of whether anybody has any opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that, based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD and BSS have any relation? Mr. Owens' objection asked and answered. The court overruled. The witness, no. Question, in what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part of about playing hide and seek. They were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him, they were still laughing, having had a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
No further questions.
Now they get to hear it twice.
Cross-examination.
That's what the defense
You may
did.
proceed, sir.
A very damaging statement to the defense's case has been heard not once and brushed off, twice, and now highlighted. You dumbass.
What all did you consider collaterally as it relates to your opinions you're expressing here today?
I had a number of documents that I reviewed. I'll look at a list. I had the Orange County Sheriff's Office investigation report. I had a transcript of a 2-hour interview of the defendant. I had a
That's the 2-hour interrogation with Detective Lowen and Detective Copson.
it was an interview, yes.
Excuse me?
Yeah.
Okay, go ahead.
It was labeled an interview. Then I had a transcript of a second interview the next day of Ms. Boone. I had medical records from Aspire Health and Advent Health. And then I had some cell phone records. And I also received the deposition of your expert.
The deposition of Dr. Julie Harper?
Yes.
Okay. And did you listen to Dr. Julie Harper's testimony in this trial of Sarah Boone?
No.
Do you agree you have a right to do that?
Yes.
And did you listen to Sarah Boone's testimony in the trial of this case?
No.
You agree you have a right to do that?
Yes.
And you elected not to listen to her testimony before expressing opinions here today?
Overruled.
I did not have time to do that.
You did not have time to do that?
Correct.
She's on trial for murder.
Yes.
There you go.
Sustained.
Rip her apart, buddy. This is your
You
time.
said you
to shine.
considered some text messages from Sarah Boone's phone.
I reviewed them, correct.
Would it be fair to say that of those text messages, they're not necessarily overly relevant?
Objection, you approach.
Yes.
What's up, Tam? Finally, he has his chance to shine. Do it, man. Like, you're doing a good job. Highlight the fact that 2.5 hour interview is terrible for diagnosis. You need more. You need more. If I don't hear that question, I'm seriously going to lose it. Because that is the most important piece. Compare her to your expert witness. That 9 sessions, just ask her, would you agree with me, doctor, that 9 sessions is better than 1? Yes or no? You get a broader picture over time of a patient. Yes or no? Are you familiar with the Goldwater rule? Yes or no?
Regarding these text messages that you were provided, did that inform your opinion that you just expressed about the inapplicability of BSS or PTSD to the facts of this case?
No.
Did it apply to your opinion that Sarah Boone suffers from battered spouse syndrome?
No.
Are that information, when you express opinions in court about a patient or about an individual, you rely on your personal assessment as well as the documents and evidence that you're provided and asked to review, are you not?
Correct.
And in this case, your testimony is that you reviewed all that information before you interviewed Sarah Boone for 2.5 hours on October the 2nd of 2024, 22 days ago.
Correct.
So you had the information,
Yes.
the documents, you read the documents,
Yes.
you read all the text messages,
Correct.
and you are going to express some opinions here today, are you not?
Correct.
You're going to express some opinions about narcissism, whether or not she had.
Yes.
And by the way, with all these objections from both sides now, they're making this expert look like she is completely destroying Sarah Boone's defense. Like she's completely ripping the case open. That's the impression that they're giving to the jury. The reality is far from it. I don't think she's doing a very good job. She did enough, but I don't know. I don't think she is a very material witness. She's just material enough to maybe get rid of the battered spouse, syndrome or whatever momentarily, but not like she's not going to be able to change the jurors' opinions. It's not, jurors don't think like that. You're not going to put on an expert and they're going to go, oh my God, everything I know is wrong. Thank you, Mr. and Ms. Expert. Like, come on. So to use and just make her like way more important than she should be made out to be is only hurting the defense. And the prosecution is writing those coattails. Now they're objecting, and maybe they have a basis for their objection. But if I'm the prosecutor, I'm just going to object for no reason, just to let them marinate, just to let the jurors sit there and be like, yeah, this witness is absolutely eating the defense alive. Of course they are. Sarah Boone is going to appeal this case no matter what, and it's going to be lawyer number 10. Because Owens is not an appeals attorney based on his profile that we read earlier. The fact that Sarah may actually believe that she's going to skate away from this is mind-boggling. She keeps smiling. She keeps smiling, and she looks like she's having a good time. Crazy stuff. Look at how happy she looks. I hope Sarah realizes that the jury sees everything. And anytime she has that little look at my face, okay? I'm gonna be Sarah Boone for a second. I'm sorry for the visual. You can tell the difference when I have like a smirk on my face, right? Even if it's just for a split second. Jurors notice these things. You're on trial for murder, lady. You cannot be smirking. Ryan thinks Boone is going to walk. You're definitely in the minority, but who knows? I am certain that she won't. You think she's going to walk? Thomas Fisher comes out with an interesting comment. He says, she is quirky. And so is Johnny Depp, Larry. Okay, first of all, you cannot compare Sarah Boone to Johnny Depp. Please. First of all, he is an A-list celebrity with a track record of 40 plus years in acting. We've seen him on stage. We've seen him on the screen. We've seen them in public. Sarah Boone is a nobody. She is an absolute nobody. She's never acted. She's a private person. The only track record we have of her is the one African American lady that testified yesterday, Ms. Walker, was it? I forget. I just realized the irony if it was Ms. Walker. What was her name? I forgot. Shoot. What was the name of the neighbor? Do you guys remember from Unit 8? Or Unit 3, whichever one she was in? What's up, DJ Radis? Yeah, it was Ms. Walker. Okay, thank you. I just realized how ironic it is that Ms. Walker was in a wheelchair. Anyway, so yeah, that's the only character witness that we had. It's the only character witness that we had. Becky Jones, yeah, the jury has got to be like absolutely furious. I mean, I would be. because we want to hear testimony. We're tired of the back and forth. We've been here for almost 3 hours as a juror, right? We've been here almost 3 hours. We're almost at the lunch break hour, and we've heard the experts say 5 words. Look at how happy she looks. Look at this. The jury is watching you every second of what you're doing, lady. You can't be smiling. Oy vey. I tell my clients when we get ready to go to trial, remember, the jury's always watching and they notice everything. 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 They notice everything. So if you're going to be a jackhole, they're going to notice. If you're going to be happy, they're going to notice. If they're going to be
Objections
sad,
overruled. You may proceed.
they're going to notice. Oh yes, Becky. Let's see. Let's hope this gets.
Ma'am, is it fair to say in your evaluation of Sarah Boone on October the 2nd of 2024 that you felt like the text messages that you received from the state attorney
Overruled.
are not relevant to your evaluation of Sarah Boone?
I wasn't sure at the time who actually, I wasn't sure whose phone number it was. In all honesty, we discussed that in the deposition, and I wasn't sure. I have no proof of who actually sent the text, who actually had possession of the phone and put the text, any of the texts in.
Well, I was there for the deposition, was I not? Or I appeared by Zoom, did I not?
No, so you were present in person.
Okay, I'm trying to think.
Oh, deposition.
The deposition.
By Zoom, yes.
You appear by Zoom, I appear by Zoom, the state attorney appeared by Zoom.
Yes.
And we discussed that these were the phone records from Sarah Boone's phone.
Yes.
Okay. And at that time, you said they're not
Yeah, oh, yeah,
necessarily
yeah.
overly relevant to your evaluation. Did you not say that?
I don't recall specifically. I'm happy to look at it.
Can I approach the witness?
You may.
I have it. If you just refer me to the page.
Just a moment.
You got it.
I do.
Page 14. My question is at line 3. Your answer begins at line 5.
Correct.
And you agree that any,
Let him finish. Let him finish.
well, I'm going on, I'm going to ask another question about the text messages, Judge.
You just said line 5. Approach.
Oh my God. You all.
Dr. Warner, did that refresh your recollection about our discussions about the text messages in your evaluation?
Yes.
And would you agree that they're not necessarily overly relevant to your evaluation of Sarah Boone?
Correct.
And you agree that after reviewing all those text messages, that there was nothing that stuck out to you that caused you to pause and feel like they may have some impact on your evaluations of Sarah Boone? Can she answer the question?
Have her answer the question first.
I'm not sure what you're referring to in the deposition.
Page 14. My question is at line 21. Your answer is at line 25.
Correct. And I said no. As I said, it made me aware that they had a volatile relationship.
But my question to you specifically is there anything in the text messages that stuck out to you that caused you to pause and feel like that may have some impact on your evaluations?
Correct.
And you agree your answer is no?
As I said, it made me aware. That's not my complete answer.
Okay, well, let's
I can
talk.
read my
First,
complete
you said
answer.
no.
As I said, it made me aware that they had a
Ma'am,
volatile
ma'am.
It's not my complete answer.
I know, Dr. Warner, but didn't you say no to me? That was your first sentence was no.
It's not my complete answer.
I understand. I'm going to let you answer that. But when I asked you if there was anything in the text messages that caused you to pause and it would in some way affect the impact on your evaluation, your answer to me was no.
It's not my complete answer.
I understand. But was your answer not to me no?
Yes, but that is not
All
my
right.
complete
Now,
answer.
at the same time, Dr. Warner, at the same time, you expressed that they had a volatile relationship.
That is not the totality of my answer either.
Okay, and I'm going to get to it.
Okay,
But part of your answer was that they had a volatile relationship.
correct?
And this is in relation to my question about the text messages. You agree?
Yes.
After you said no, you said they had a volatile relationship and that she text messaged calling him an idiot, a fucking idiot for overdrafting her account.
Correct.
And in those text messages, there was some reference to domestic violence between the two.
Correct.
And that demonstrated to you that they had a violent relationship.
Correct.
And do you not agree that that evidence of a volatile relationship had an effect on you expressing your opinion here today that Sarah Boone suffered from battered spouse syndrome?
Judge, we need to object. We need to approach.
He's doing a better job. I still think he's missing a few questions. I mean, it's easy for me, you know, I'm litigating from the armchair, from the comfort of my home. I mean, at this rate, we're definitely not going to have a verdict tomorrow. We may not even get the closings tomorrow. No, the judge is not going to put his foot down because he wants to have a nice, clean trial. He can't stop the prosecution or the defense from objecting. Yeah, they're going to break for lunch in like 5 minutes. I just can't wait for the body cam footage, folks. I thought by now we would have at least started it. We're not even done with cross-examination. So we've got a ways to go. And I was misled. I misled you guys yesterday. I said that the body camera footage is going to be probably boring. Apparently, my girlfriend Chandler, who has seen some of it, says it's going to be entertaining. It's going to be very interesting. So now I'm kind of looking forward to it. Yeah, apparently it has been, but now we get to see it in court, and I've never seen it. So Angela says she has seen it 10 times. 10 times. Well, it's about to be 11. Why'd you watch it so much? Is it that interesting? That entertaining? Or were you trying to find like loopholes and pitfalls or whatever? I know she keeps asking for like cigarettes and a Dr. Pepper, crap like that.
All right, members of the jury, it is 11:55. At this point in time, we're going to go ahead and take our lunch break. I'm going to give you a similar instruction that I've given you throughout the last couple of days. Give me a moment to pull it back up. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again, bless you, that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, we're going to be in recess till 1:30, and we'll pick up at that point in time. Thank you so much for your service.
1:30.
Y'all may be seated. State, anything else?
No, Your Honor, thank you.
Defense? All right, we'll see you at 1:30. Thank you very much. Court's in recess.
All right, folks. You're going to be pushed in to the other stream, and I will see you at 1:30.